May it please the court. My name is Shemaiah DeGiorgi, and today I, along with my co-counsel, Maeve Durkee, proudly represent the petitioner in today's case. Brendan Koch of New York applied for a concealed carry license in September of 2014. Motivated by his extensive experiences with firearm use, as well as his desire for self-defense, Koch's application for a permit was denied because he did not demonstrate a special need for a firearm and did not have a proper cause to carry one. Proper cause is required by New York penal law, in Penal Law 400, in order to obtain a concealed carry license. Also, in September of 2014, Robert Nash of New York applied for a concealed carry license. Nash had participated in a gun training course and was motivated to carry a gun for fear of robberies that had been occurring in his neighborhood. Like Koch, Nash's permit application was denied. Neither Nash nor Koch had any criminal history. Koch and Nash sued Justice Richard McNally and Superintendent of New York Policy Kevin P. Bruin in their official capacities. Koch and Nash are joined in their suit by the New York Rifles and Pistol Association, or NYSRPA, representing all residents of the state of New York who cannot obtain a concealed carry permit because they cannot demonstrate a special need for a firearm and therefore do not have proper cause to carry one.
The Constitution enshrines a generalized right to bear arms outside of the home for self-defense, unrelated to military activity. Legal scholars and lawmakers have interpreted the Second Amendment to be an individual right as long as the Second Amendment has existed, and at the time the Constitution was written, to bear arms meant to take them outside of the home, and Supreme Court precedent codifies the above interpretation of the Second Amendment. The New York statute infringes upon this right to bear arms by making it illegal for ordinary citizens to exercise it at all, and also fails to pass any level of scrutiny that this court has used to analyze laws that regulate enumerated rights due to its overly broad nature and failure to further the state's interests in public safety. Furthermore, there is no court precedent that supports the passage of a total ban on bearing firearms for the average citizen, and Second Amendment restrictions that have traditionally been allowed to persist are all extremely different from and substantially less restrictive than the law at the bar today.
Well, counsel, what does the Second Amendment protect?
The Second Amendment protects the individual right to keep and bear arms for the primary purpose of self-defense.
The Constitution enshrines a generalized right to bear arms for self-defense that is unrelated to military activity, which the New York law overtly violates. The history surrounding the Second Amendment indicates that it confers a right that extends beyond the home and one that is unconnected with military service. To keep and bear arms has historically both extended beyond simple gun ownership and has been unconnected to either militia or military service. There is a long history of the idea of keeping and bearing arms referring not to use in militia service, but to possession and use by common people. The English Bill of Rights of 1689 inspired the Bill of Rights. That is
Counsel, why did the framers include the Second Amendment in the Bill of Rights?
The framers wanted to guarantee that the American people would have access to one of the fundamental rights of Englishmen, and they wanted to prevent the American people from being disarmed by an oppressive government.
Well, counsel, then on top of that question, what are the limits of the Second Amendment's protection?
The limits of the Second Amendment's protection are people who the longstanding exceptions to the Second Amendment apply to.
Yes, as long as those exceptions were rooted in the time of the founding. The English Bill of Rights of 1689 inspired the Bill of Rights that we use in America, the Eighth Amendment being taken wholesale from it. In the English Bill of Rights, Protestants are given the right to bear arms for their defense, meaning the document that inspired the Bill of Rights directly referred to the right to bear arms in terms of self-defense, not military or militia service. In 1716, the Disarming Act was passed by the British Parliament. It forbade people living in specific areas of Scotland from having in his or their custody use or bear a broadsword, target, poignard, whinger, or dirk, side pistol, gun, or other warlike weapon without permission. This act did not prevent people from wielding weapons as part of a militia. It prevented them from possessing or using them at all. Blackstone's commentaries, which were widely read in the colonies and influenced the founders, show that the idea of keeping arms for personal defense was present before the Constitution was even written.
Counsel, what weapons does the term arms include?
The term arms includes all weapons that are in common use at the present day, even if they were not in use at the time of the founding, pursuant to the decision that was made in D.C. v. Heller. He wrote in 1765 of the right of Englishmen to have arms for their defense, only in terms of personal protection, not militia service. George Tucker wrote, only 15 years after the Constitution was ratified, that the right of self-defense is the first law of nature. Wherever standing armies are kept up, and the right of the people to keep and bear arms is prohibited, liberty, if not already annihilated, is on the brink of destruction. His commentary shows that he, as a legal scholar and later as a federal judge, interpreted the right to keep and bear arms as primarily a right to tools of self-defense. It also shows that standing armies and the people were completely separate groups, at odds with each other and not the same entity as respondent claims. At the time of the writing of the Constitution, to bear arms meant to bring outside of the home, and the Constitution was immediately interpreted as such.
So, what is the difference, if any, between the words keep and bear?
To keep arms and to bear arms in the Second Amendment are completely different. To keep arms is to keep in one's home, whereas to bear arms is to bring outside of one's home for purposes of confrontation.
Samuel Johnson's Dictionary of the English Language, published in 1773, defined bear as to carry, so we say to bear arms in a coat. And Noah Webster's Dictionary of the English Language defined it as to wear, as to bear a sword, to bear arms in a coat. Bearing arms during the writing of the Constitution was clearly an activity separate from keeping, and was most often done outside of the home, as coats are not often worn indoors. George Tucker also wrote, the right to bear arms is recognized and secured in the Constitution itself. In many parts of the United States, a man no more thinks of going out of his house on any occasion without his rifle or musket in hand, than an European fine gentleman without his sword by his side. When speaking about the right to bear arms, only 15 years after the ratification of the Constitution, a legal scholar spoke explicitly and only of leaving the house with the arms of the time, rifles and muskets.
Supreme Court legal precedent codifies the above interpretation of the right to bear arms. This court has set the conclusive precedent that the right of the people to keep and bear arms is unrelated to militia service and extends beyond the home in a multitude of cases.
Counsel, what is a militia and why did the framers refer to it in the Second Amendment?
A militia is a group of common people brought together for defense of property or enforcement of the law. The framers included militia in the prefatory clause to announce a purpose, but militia service does not limit the secondary clause of the Second Amendment at all. And this court has set the conclusive precedent that the right of the people to keep and bear arms is unrelated to militia service and extends beyond the home in a multitude of cases. The most notable case is District of Columbia v. Heller. The court held that the prefatory clause does not limit the operative clause, but rather announces a purpose. The amendment could be rephrased, because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And there is a strong presumption that the Second Amendment right is exercised individually and belongs to all Americans, not just those part of or eligible to be in a militia. And the inherent right of self-defense has been central to the Second Amendment right. As ruled in United States versus Vergudo-Urquidez and cited in Heller, the phrase "the people" seems to be a term of art used in select parts of the Constitution, and "the people" refers to a class of persons who are part of a national community. The Second Amendment confers the right to keep and bear arms upon the people, not militia members, for the purposes of self-defense, not militia service.
Counsel, well, how should courts determine if a gun control regulation is considered long-standing?
This court should rely on historical tradition. If a restriction has roots in the founding, whether through the rationale behind it or specific analogs to it, then it should be considered long-standing. However, if it is a more modern interpretation that has been conjured up after the founding, then it cannot be considered to be long-standing.
Heller also held that to keep arms and to bear arms are two separate actions, both of which the people have a right to. This court ruled that the most natural reading of keep arms in the Second Amendment is to have weapons, and that to bear arms is to wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action in case of a conflict with another person. The people of the United States have the right to both keep arms inside their homes and bear arms outside of their homes. This court has continued to uphold the conclusions of Heller in McDonald v. Chicago. In McDonald, this court held that Individual self-defense is the central component of the Second Amendment right.
And counsel, what is strict scrutiny, intermediate scrutiny, and the rational basis review?
Well, Your Honor, all three of them are standards of review that the Supreme Court has used to analyze cases that deal with the infringement upon enumerated rights. Strict scrutiny is the highest level of judicial scrutiny, and it requires a law to demonstrate that it furthers a compelling state interest and is the least restrictive means of furthering that interest. Intermediate scrutiny is the second most stringent standard, and it requires a law to demonstrate that it furthers a substantial interest and is narrowly tailored to meet that interest. And rational basis is the lightest standard of review, and it only requires that it be rationally related to a specific state interest and that it furthers it in some way. The New York law infringes upon that right, as it makes it illegal for ordinary citizens to exercise it at all. The Second Amendment guarantees the right to keep and bear arms to the people, and the New York statute prevents the vast majority of the people from exercising their constitutional right. The statute reads in part, "No license shall be issued or renewed pursuant to this section except by the licensing officer, and then only after investigation and finding that all statements in a proper application for the license are of true and good moral character, and proper cause exists for the issuance of a license." To have proper cause for the issuance of a license, a person must demonstrate a special need for self-protection, distinguishable from that of the general community or from persons engaged in the same profession. And a generalized desire to carry a concealed weapon to protect one's person and property does not constitute proper cause. New York City had 468 murders last year, whereas many towns in New York had no murders. A person living in Lake Placid and a person living in New York City would have very different levels of day-to-day danger, and yet without any special need, neither of them could acquire a license to carry a gun. The New York statute does not simply prevent felons and the mentally ill from carrying guns, which is permissible under the Second Amendment as held in Heller. As held in Heller, nothing in our opinion should be taken to cast doubt on the long-standing prohibitions on the possession of firearms by felons and the mentally ill. The New York statute prevents all but a special class who have a special need for protection from carrying guns, and the vast majority of the people who are protected under the Second Amendment, such as Mr. Nash and Mr. Koch, cannot bear arms in clear violation of the Second Amendment and the Constitution.
The New York law fails to pass any level of scrutiny that this court has used to analyze laws that regulate enumerated rights, like the Second Amendment. In keeping with the ruling in D.C. v. Heller, the New York law must be using strict or intermediate scrutiny. In Heller, this court held that only strict and intermediate scrutiny can be used to analyze legislation appears on its face to be within a specific prohibition of the Constitution, such as those of the first 10 amendments. The Heller court declared that rational basis scrutiny cannot be used to evaluate the extent to which a legislature may regulate a specific enumerated right, and that if all that was required to overcome the right to keep and bear arms was a rational basis, the Second Amendment would be redundant with the separate constitutional prohibition on irrational laws and would have no effect. As the New York law, through imposing in practice what amounts to a total ban on the carrying of firearms for the average law-abiding citizen, is blatantly within the Second Amendment's prohibition on government infringement of the right to bear arms, only strict and intermediate scrutiny can be used to determine its constitutionality. The New York law fails to satisfy both of these, as it cannot be found to further a state interest in public safety, nor can it be found to be narrowly tailored in serving that end.
The New York law's denying of law-abiding citizens the ability to exercise their Second Amendment rights cannot be found to further a governmental interest in public safety, as empirical data overwhelmingly suggests that individuals with licenses to carry are not a significant threat to public safety. Statistically, it is not the individuals who obtain lawful permits that commit violent crimes. It's the ones that don't. According to the Violence Policy Center, America's 18 million concealed carry permit holders accounted for 801 firearm-related homicides over a 15-year span, or roughly 0.7% of all firearm-related homicides during that time. Furthermore, data from an expansive study conducted by David P. Coble found that licensees commit violent crimes at extremely low rates, and in the vast majority of states at lower rates than the general public. For example, the study found 161 charges involving handguns in Michigan out of approximately 190,000 licensees in 2007 and 2008, while the general population produced 1,018 violent crimes per 190,000 people during that same time frame. The study also found that even in Texas, a state with some of the least restrictive gun laws in the country, licensees are 79% less likely to be convicted of a crime than non-licensees.
Counsel, is there a difference between openly carrying a firearm and concealed carrying a firearm?
There is. Prohibitions against openly carrying a firearm fall under long-standing prohibitions and are not prohibited by the Second Amendment, whereas prohibitions on concealed carrying a firearm are unconstitutional under the Second Amendment.
Furthermore, Louisiana having a firearm misuse rate of just over 1 in 1,000 licensees, Minnesota having 1 handgun crime per 1,423 licensees, and Florida having only 27 firearm crimes per 100,000 licenses. The statistics also overwhelmingly suggest that transitioning from a highly restrictive licensing system to a less restrictive one does not cause a significant increase in violent crime. According to the VPC, since 2008, the year that Heller struck down DC's total ban on handguns, there have only been 12 victims of unlawful homicide that was perpetrated by an individual with a concealed carry license. When that number is compared to the 1,804 total victims of homicides that have occurred in DC since 2008, according to the DC Metropolitan Department's year-end crime data, we find that individuals with concealed carry permits have been responsible for 0.0066%, or roughly 2/3 of 1% of deaths from homicide in DC since Heller.
Furthermore, according to the VPC, or Violence Policy Center, since 2017, the year that a decision concluding that the individual right to carry common firearms beyond the home falls within the core of the Second Amendment in Wren v. District of Columbia, there has not been a single unlawful death caused by a permit holder in Washington, D.C. Not only does the data overwhelmingly support the assertion that licensees do not increase rates of violent crime, it also suggests that having laws that leave an avenue to obtain weapons actually reduces it. As recognized in McDonald v. City of Chicago, after a Chicago law that essentially instituted a total ban on handguns was passed, Chicago Police Department statistics revealed that the city's handgun murder rate has actually increased, and that Chicago residents now face one of the highest murder rates in the country and rates of other violent crimes that exceed the average in the comparable cities. As a result, all this data supports one conclusion, that not only are licensed individuals not a threat to public safety, but that at the presence of laws that prevent people from exercising their Second Amendment right are. Therefore, the New York law, which outright prevents the average person from obtaining a license to conceal carry, cannot be found to further a state interest in public safety.
Furthermore,
Also, how should the court consider the public safety implications of licenses to carry firearms?
the court should not consider the increase of licenses, of concealed carry licenses that will be prevalent after the overturning of this law to be a threat to public safety, as the empirical data overwhelmingly supports the assertion that individuals with concealed carry licenses are not a threat to public safety, as they are not overwhelmingly not the ones that commit violent crimes. The New York law is not narrowly tailored, as it prevents every average law-abiding citizen from bearing a handgun, thereby imposing a restriction that is just as broad as the one that imposed by the law struck down by D.C. v. Heller. This court has repeatedly established that in order to satisfy intermediate scrutiny, a law must be narrowly tailored to serve a substantial government interest. This was held most recently in Americans for Prosperity Foundation v. Bonta, but it has been held numerous times in earlier cases, such as Packingham v. North Carolina and McClellan v. Coakley. New York's laws cannot be found to satisfy the narrow tailoring requirement for the same reason that the law in Heller wasn't. In its attempt to prevent the small minority of people who would abuse handguns from doing so, it prevents the average law-abiding citizen from using them in a constitutionally protected way. In Heller, this court acknowledged that the Second Amendment states that the right to keep and bear arms belongs to the people, and defined the people as the class of persons who are a part of the national community or who have otherwise developed sufficient connection with this country to be considered a part of that community. In other words, Heller interpreted the people as it is used in the Second Amendment to refer to the average citizen of the United States of America, outright stating that the Second Amendment confers a right that belongs to all Americans. Specifically stating that their opinion did not cast doubt on the longstanding prohibitions on possession of firearms by small and specific subsects of people like felons and the mentally ill, the court struck down a law that imposed a de facto ban on the possession of handguns because it prevented the average member of the national community from exercising their Second Amendment right to keep arms. Just like the DC law imposed a total ban for the average person on the constitutionally protected activity of keeping arms within the home, the New York law imposes a total ban on the constitutionally protected activity of bearing handguns outside the home. The court in DC v. Heller held that on the basis of both text and history, the Second Amendment confers an individual right to keep and bear arms. They did not say that it conferred a right to keep and a lesser right to bear. They did not say that it conferred a core right to keep and a periphery right to bear. They said that it conferred a right to keep and to bear arms. The implication of this being that the right to keep and the right to bear are equal rights that are subject to the same protections from infringement. As such, just like the law in Heller was considered to not have constitutional muster under any level of scrutiny due to its total ban on the keeping of handguns for average citizens being overbroad, the New York law at bar should also be considered to be overbroad due to its total ban on the bearing of arms and also not have any constitutional muster.
There is no legal or historical precedent for a law that completely prevents average law-abiding citizens from exercising their Second Amendment rights that is respected by this court. There is no court precedent that supports the passage of a total ban on bearing firearms for the average citizen. Very few laws have come close to imposing the level of restriction that the New York law places on the Second Amendment, and the minute number of laws that did were overturned by the courts below this one. One such law was the one at bar in Nunn v. State, which, similarly to the New York's law's total ban on the carrying of firearms, attempted to impose a prohibition on the opening and carrying of pistols. It was overturned by the Georgia Supreme Court on the grounds that it placed too great of a burden on individuals' Second Amendment rights. Furthermore, in Andrews v. State, the Tennessee Supreme Court likewise held that a statute that forbade openly carrying a pistol publicly or privately without regard to time, place, or circumstances violated the state constitutional provision, which the court equated with the Second Amendment. The court held that to be so, even though it acknowledged that, like the New York law at bar in this case, the statute did not restrict the carrying of other types of guns in the same way. In contrast to the lack of precedent in support of local prohibition laws, there is plenty of Supreme Court precedent that opposes total prohibition laws. In addition to the previously referenced Heller, the court in State v. Reed held that a statute which, under the pretense of regulating, amounts to a destruction of the right or requires arms to be so borne as to render them wholly useless for the purpose of defense, would be clearly unconstitutional. Laws, like the New York law at bar, which impose total prohibitions on the exercising of Second Amendment rights by definition, amount to a destruction of Second Amendment rights and are therefore unconstitutional pursuant to Reed. While laws, like the one at bar, which impose total prohibitions on the exercising of Second Amendment rights, have no precedent behind them, the laws that have been allowed to persist are all from extremely and substantially less restrictive than the law at bar today.
The surety laws, sensitive place restrictions, and prohibitions of the keeping and bearing of arms for small subsets of people are all Second Amendment rights that have traditionally been allowed to persist, are all extremely different from and substantially less restrictive than the law at bar today. Under the surety laws, courts were empowered to demand a surety, a fine, from individuals who abuse their Second Amendment rights and restrict their right to carry arms if the surety was not paid. This is very different from the law at bar today, as under the early surety laws, everyone started out with robust carrying rights, pursuant to, as was recognized in Wren v. District of Columbia, and a surety could be demanded only upon proof of reasonable cause to believe that someone was going to abuse that right. Even then, moreover, one against whom a surety complaint was sustained was free to continue carrying arms so long as he paid the surety. In contrast, under the New York law at bar today, every average citizen begins with no carrying rights outside the home and must demonstrate an atypical need to carry that distinguishes them from their law-abiding peers. Furthermore, the surety laws only imposed a burden on individuals who had proven themselves a potential danger to society and still gave those people an avenue to alleviate that burden through paying the surety. In contrast, the New York law, by definition, imposes a burden on the overwhelming majority of law-abiding citizens who have done nothing. That indicates that they would pose a danger to society if given firearms, and provides them with no avenue to alleviate that burden so long as they remain average citizens. Similarly, sensitive place laws and laws that impose prohibitions on the bearing of arms for people with certain traits like felons and the mentally ill are also very different from the New York law, as their restriction only applies to a narrow subset of people. The prohibitions imposed by sensitive place laws only apply to the narrow subset of people who wish to enter a small and defined location, such as a school or a government building. Similarly, laws that prevent people with traits that would make them a danger to society if entrusted with firearms from getting them only apply to the narrow subset of people who possess those traits. In contrast, the New York law prohibits the vast majority of people in the entire state of New York from bearing arms outside of their home. Due to this massive discrepancy of scope of the New York law and the types of Second Amendment restrictions that have traditionally been upheld, the law cannot be considered to be analogous to them and therefore cannot rest on them as a historical basis for its existence.
In conclusion, this court should reverse the Second Circuit's decision and find in favor of the petitioner. Both tradition and Supreme Court precedent recognizes that the Second Amendment confers a generalized right to bear arms outside of the home for self-defense, unrelated to military activity. The New York statute infringes upon this right to bear arms by making it illegal for ordinary citizens to exercise it at all. This infringement fails to pass any level of scrutiny that this court has used to analyze laws that regulate enumerated rights due to its overly broad nature and failure to further the state's interest in public safety. Furthermore, there is no court precedent that supports the passage of a total ban on bearing firearms for the average citizen, and Second Amendment restrictions that have traditionally been allowed to persist are all extremely different from, and substantially less restrictive than, the law at bar today. Not only does this law possess no basis in court precedent, it also has no basis in tradition.
It is for these reasons we pray that the court reverses the decision of the lower courts and rules in favor of the petitioner. Thank you.